The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And good morning, and let me first welcome Pete Dammel and the students from Audubon. Thank you so much for being a part of our court proceeding this morning, and I, of course, have fond memories of your school, having visited a couple of years ago, so thanks so much. We have 3 cases that will be submitted this morning. Those cases are Shelley Freer versus DAC, Inc., doing business as Prairie House. Second case is Ross Barker versus the Iowa Department of Public Safety. And the last case is the Iowa Supreme Court Attorney Disciplinary Board versus Brian Humphrey. That last case is now submitted to the court without an oral argument, and we'll proceed to hear the argument in the Freer case. And Mr. Kyle, you may proceed.
Good morning. May it please the court. And I apologize. I'm fighting my first cold of the season, so my voice will crackle. I have water here. I use it. I apologize if it slows us down. I'm Tom Kyle. Sitting with me here is Michael Boomershine. We represent the estate of Nicole Sansom, Shelley Freer, who's the mother of Nicole Sansom, and Michael Sansom, who is the father. This case is a civil trial case, a case that went to trial in Maquoketa. The trial story is important and ties into a lot of the appellate issues that are in front of this court. Briefly, Nicole Sansom was a Down syndrome adult living in a group home in Maquoketa. She was a known food hoarder. She was a known food gorger. In the early morning of July 5th, she got up unnoticed, got into the kitchen, found peanut butter, and gorged herself to the point that she clogged her trachea and was passed out unresponsive on the ground. When she was eventually found, ambulance paramedics were called. They took her to the Maquoketa Hospital. Then they took her to Iowa City, but at this point, too much damage had been done for hypoxia, lack of oxygen, and she was pronounced dead. We sued DAC, doing business as Prairie House, in Maquoketa. Defense only retained one expert on liability. That was an ex-employee of the DIA. Had worked there for 40 years investigating adult group homes such as the one Prairie House. Any good trial lawyer always anticipates the defense, and we did. Our fear was that that witness would be brought forward, say, I did this for 40 years, I investigated like the DIA found there were no violations. If the DIA found no violations, that would leave potentially the jury to believe that there was no negligence. So we filed a motion in limine. The motion in limine was filed, it was briefed, it was argued. Trial was set for July 10th. We argued the motions on July 3rd. The judge wrote an opinion which he published on July 6th, 4 days before trial. There was a page and a half dedicated just to that motion in limine, and it was granted. Trial started on July 10th in Maquoketa. When we started trial, we got to our opening statements. We got through that. The defense got to his opening statement. During that opening statement, there was mention of the DIA.
Counsel, frankly, I understand the nature of your concern under the Houston case and the ruling of the court in limine and so forth. But you've got this agreement of some kind, this the high-low agreement. And the question that I'm most interested in is what that agreement meant. It could have meant a couple of things. It could have meant, well, it only applies to damages and preserves all your claims. I know that's your position. On the other hand, I mean conceivably, it could have meant, that's it, whatever the jury comes back, we're done. It's a cryptic 6 words, is it, or 7 words, or 8 words, or however many words, but it's very cryptic. Nonetheless, if we construe that to mean that whatever this jury comes back with, we're going to follow, then you lose. On the other hand, your suggestion is that buy-sell, or not buy, high-low, it should be narrowly construed. So help us out. Why are you right on what amounts to a narrow construction of those words?
Well, I'm glad you brought up State v. Houston. And when the objections were made, the motions and mistrials were made, based on Houston, we obviously had that case because we briefed it for the motions in limine. We thought, hey, we're going to retry this case no matter what. And we had what we thought was a slam-dunk chance at appeal once that mistrial motion was made.
But focus on, I mean, here's what I have. I mean, I've got, again, mathematics, 10 words. It strikes me there may be some ambiguity as to the scope of what those 10 words meant, or 6 words, or 9 words, however many there were.
Sure.
And on first blush, I can see it being broadly construed to say, hey, we're done with this litigation. We're going to do a high-low arrangement, or whatever this jury comes back, that's what we're going to do. It doesn't say that expressly, of course. Or it could be, so give me the tools to decide this case. And it seems to me it's a question of what's the meaning of those handful of words.
In the tools to decide this case, and that's an excellent thing, and I'll address it right now. And I apologize for going so slow and getting about it in a roundabout way, but the idea is we thought we had a slam-dunk appeal. As it moved forward, other things happened where the jury asked questions that led us right to believe, again, the jury focused on the DIA. There was a jury question submitted, which I never heard from the judge that got submitted until after the verdict. To this day, I don't know if defense counsel heard whether that, about that question, but that following morning, I got the call. I don't want to beat around the bush, and I'll go right straight to it. The idea is the appeal was a slam dunk. We thought we had it nailed for sure. If that appeal was something that I was bargaining away, it sure as heck would have been in my email that said we agree to a high-low. So all those things being said tie in to our intent and mindset when we entered into the high-low.
But let's go into that email exchange. All right, so you write, they agree to the high-low of 100,000 to 1 million, they meaning your clients, right?
Correct.
And then defense counsel writes back, confirmed, now we wait and see what the jury does. That sounds like at least defense counsel is reading the high-low as whatever the jury does is going to be whatever goes, right?
I guess I didn't read it that way. I mean, the idea is if it would have came in somewhere where they made some type of award, I guess I would agree with you.
Question as well.
I'm sorry.
You said a little bit ago that if you were going to be bargaining away the right to appeal, you would have said that. Isn't it true you could have also said, I'm not bargaining away my right for appeal?
Oh, sure. Yeah, I absolutely could have. But, I mean, the record supports itself in that I raised the issue of appeal 3 to 4 times during the case, and knowing what we knew going into it, if I were to bargain for that appeal, which I thought we had a slam-dunk chance of appeal, I wouldn't have gone 101 million. It would have been 501 million. I mean, you would have had to pay for that appeal. Now, as far as the high-low agreement, I'll take one step back. As far as the high-low agreement goes, the concern, and I think in the New York cases they pointed out, the danger is this, of reading in to every time someone says high-low that you give away an appeal. What about juror misconduct? What about witness misconduct? What about everything you can find out after that high-low that you would never know?
Let me ask you this. I mean, when the question came back, well, we'll wait and see what the jury says. Does that put a burden on you to kind of say, well, it doesn't depend on what this jury says, because we've got, this is a flawed verdict. Well, let me just rest it there. Shouldn't you have responded, say, oh, no, it's not this jury, it's some future jury?
Well, I guess if I was thinking of what my intent was and how I considered a high-low agreement, here's how I consider it. They came back with no negligence. They don't owe me anything. They came back with negligence and no money. They owe me $100,000. They come back with negligence and $5 million. They owe me $1 million. You win the case and don't lose $100,000. I'm talking about from the defense side. I mean, that's a strict interpretation of what a high-low would be. The idea is you win the case. You lose the case, you don't owe anything.
What do you make of what the judge at least says, a statement was made to him, thank God we entered into the high-low agreement. What do you make of that?
Well, that troubles and concerns me for two reasons. Number one, the communication with the judge throughout the trial, and even with those jury questions, weren't with both of us. They were just calls to each one of us. The call to me was this: they didn't award you any money. The call to me wasn't, you lost on liability. That I never knew.
Why didn't you say, well, we got an appeal anyway because the Houston issue?
Well,
I mean,
and I don't want to backpedal and get back to where I was before, but the judge was well aware of this. I mean, the judge, if you look at some of the strong language he used in admonishing defense counsel for using what he did in front of the jury and how many times it was done, you merely have to take a look at some of the case law that says, watch out for this.
And yet after that, you entered into the high-low, correct?
After what?
After those comments by defense counsel during.
Well, absolutely. I mean, that's kind of why I wanted to lay out the proceedings and how everything went in the timeline.
What if instead of having this high-low, you had he had simply offered $100,000 to settle this case right here now, and you would accept it? It'd be game over, right?
Well, it would be game over if it was to settle the case and no appeal. A high-low doesn't necessarily settle anything. It sets a parameter of damages.
Well,
which you
doesn't
can
it?
fall in or go out.
Doesn't the high-low guarantee you're going to get $100,000 no matter what the outcome of the jury verdict, and you're going to get no more than $1 million even if the jury awards that? So it settles the case within this range, right?
If I win liability. If I don't win liability, they don't have to pay me. That's some of the reasons that different states say, just because you say high-low, doesn't bring in everything. Doesn't bring in, you find out later there's juror misconduct, there's witness misconduct, there's a question to the jury that you never knew about.
But you knew about the violations of the order in limine, or the alleged violations, the evidentiary error, the Houston issue, all that you already knew about when you had the email exchange on the high-low agreement.
Yes.
It just seems to me if you wanted to have an exception for a right to an appeal, it needed to be expressed in that email. It need to be part of that contract, and your silence means it's going to be $100,000 or $1 million or something in between.
And I guess I see how you can read it that way. I obviously read it a different way. Contract law reads it a different way. I mean, these are contracts. Unless we're going to make a blanket rule, it says every time you get into a high-low, you just give away the farm, and you don't need to win liability. I completely understood that I needed to win liability. I lost liability. I didn't come and say, give me the $100,000, and then we'll go and we'll try to appeal this thing and get more later. I've never once ask for the $100,000. If that is something that points directly to my intent and where my head was, I mean, obviously, there's case costs in here, there's money owed. I never once said.
But
and
since
that-
we're on different wavelengths on what a high-low agreement means, and our court doesn't have much precedent on it, is this case a good vehicle for us to set out some ground rules?
Well, I think it's going to be dangerous, and I think it is going to conflict with existing contract law. When you have two lawyers entering into agreement, I'm sure we've all done some contract work, you would think that they'd make sure they'd put everything needed be to end a case, especially if there was appeal. Let's flip it the other way, too. If the other side was worried about appeal and the other side was worried about some kind of malfeasance at trial, it wasn't mine. Wouldn't you want to put in there the intent and say, hey, it's a high-low, it's $100,000, $1 million, and no post-trial motions, and no appeal? Because the appellate issue was mine.
What do we do about the absence of a written ruling? Can we reach the merits conditionally and then on remand have the trial court enter a ruling?
Absolutely. That's the now for then order. That's the Wilson case, which is, I said now for then, it's obviously the Latin, I skipped there. But the point is, that's all in place. And I think, maybe you know the deal, with the judge retired shortly after this case. This is the last case he tried, and he went on to bigger and better things. So, yes, short answer to your question, the vehicle's in place through the Wilson case, and absolutely we could.
All right, thank you, counsel. Mr. Woodward, you may present your argument.
May it please the court. Good morning. I'm Pat Woodward. I represent DAC Inc. DAC Inc. is a nonprofit corporation for providing services to people with intellectual disabilities. Prairie House is a creation of statute and regulations to provide a group home setting for individuals. It's an intermediate care facility for individuals with disabilities. One of those individuals that came to Prairie Home was Nicole Sansom. One of her behaviors, which was being dealt with by Prairie House, was food stealing.
What's the real issue in the case is, it strikes me, at least as it's presented to us, as a contract question. And we have these handful of words, this high-low agreement. I mean, the first question to me is, what does this agreement mean? Is it ambiguous? And if it is ambiguous, then how do we construe it? So, you heard the colloquy before. Why don't you dive in?
Sure.
Let me ask you first, is it ambiguous?
I don't believe it's ambiguous. The history of this was, during the course of trial, I had made several
If you're
settlements.
going off in history, it sounds like it's ambiguous. I mean, the plain, when I look at the words, although I'm very intrigued by this jury question follow-up, but when I look at the words, I'm not sure what it means. And I want you to push back and say I ought to look more closely.
Well, and I don't mean to give a lot of history. I just mean, during the course of trial, I had made several settlement offers without a response. On July 17th, July 18th, the jury got this case. On the morning of July 19th, I, from home, received a call from my client saying, offer a high-low settlement agreement. We want this over with. I make a phone call to Mr. Kyle. He doesn't answer his phone. I get his voicemail. I leave Mr. Kyle a message that says, I now have authority to offer you $100,000, regardless of what happens, million, high-low.
What was meant by we want this over with?
we did not want any appeals, we did not want any post-trial motions. When Judge Smith called me with the results of the case, first thing I said to Judge Smith was, well, no post-trial motions, no appeals. That's what our intent was. And my intent was, once we had a verdict, we knew what we were going to pay, somewhere between $100,000 and $1 million.
How did you convey that intent to the other side?
With my phone call.
I don't see the
and
phone
the
call,
history.
I don't see the phone call on the record.
No, the only one that has the phone call is Mr. Kyle on his voicemail.
What does the record show on all this communication?
The record shows the response from Mr. Kyle at 9:48 that says, my clients accept the high-low agreement, I believe were the words.
And the high-low agreement is contained within the verdict, right? And a verdict is not a judgment, it's not a final adjudication of the trial, it's not an end to the process.
The verdict defined our settlement. If it was less than $100,000, 0 to $100,000, we would pay $100,000. My client was offering that to complete this case.
But
Finalize
you said the settlement negotiations had not been successful, so you tried
Up to that time.
another avenue with this side high-low agreement, depending on what the verdict was.
Correct.
So a settlement is a final, leads to a final resolution, but does a verdict?
The entry of the judgment on the verdict,
A different process later in time.
correct. And in my opinion, what I think, we have this high-low agreement pending. We have the verdict entered, and at that point, I have a settlement. The only thing which is left at that point is to pay my money, and this case is over.
Well, didn't you have an agreement conditioned on what the verdict was? And if the verdict was more than $1 million, you would agree that it would be reduced to $1 million.
Correct.
And if the verdict was less than $100,000, you would agree that the amount would be increased to $100,000, and anything in between was there.
Correct.
So this was just a little side agreement, but the process, the trial continued forward.
The jury deliberation continued forward.
All right, so should we treat it any differently than any other trial or any other verdict determination?
Yes, I think it is a settlement. I think for
Isn't there a
31
vast difference between a settlement and changing the amount of the verdict at the end of the trial?
No, I don't believe so. I believe at the point at 9:48, when he accepted the high-low agreement, at that point, the verdict was only going to be used to determine the amount we were paying.
What if the verdict was $1.4 million, but the verdict was terribly flawed? The verdict was flawed because of inadmissible evidence, the verdict was flawed because of fraud, the verdict was flawed. Do you still pay the $1.4 million, even though the verdict is really not a real verdict if it's not enterable?
Yes, I think it is, because we knew everything which had transpired over the last 7 days of trial testimony. We knew everything which had gone on.
But you're hanging your hat on that this was done after the case was submitted.
I think
What if
that,
it was done before the case was submitted? Do you get a different result if you have a flawed verdict?
I don't believe so. I believe when we enter into a settlement, and
If I enter into a high-low with you, and then I know the maximum I get, why wouldn't that allow me as your opponent to do all kinds of shenanigans, not get a new trial, because I can't get a new trial, and not, as long as I don't get a mistrial, of course, and do all kinds of things that aren't proper in order to boost that verdict up. I mean, that doesn't make sense to me.
I see your point, Your Honor. But in this case, it was done after everything. We knew what everybody had done. We knew everybody's actions. And I go back to,
Let me take you a different direction. I'm going to take you backwards a little bit. You said you think that this high-low is a settlement. Would you agree with me that a high-low does not alter the jury's formally announced outcome, and like a settlement agreement does, that you're not going to go to a jury, you're done? Isn't there a distinct, bright line between those two?
well, I don't think so, Your Honor. I think the high-low is governed by the jury verdict, in that the jury verdict is going to set the amount of the settlement, the final amount of the settlement. The settlement is agreed to. You know, this court has always had the principle that a settlement finalizes litigation.
How do we know this is a settlement? I mean, you say this is a settlement. It doesn't, I mean, when I look at the exact exchange of words, I don't see settlement. I see high-low language. So how do you come to the conclusion that this was a settlement based on the actual language that was used?
Because I'm paying a minimum of $100,000 and a maximum of $1 million to put an end to this litigation.
Yeah, to put an end to the litigation, where do you get that? I mean, high-lows can be used in all kinds of contexts. You can have full rights of appeal, full rights of retrial, and a high-low agreement in place. You can agree to high-low for the sole issue of limiting damages and proceed. I mean, that's their position.
Yes.
And you're saying, of course, well, it was a settlement.
And that's based upon what we have always done in Iowa. We have always, had the principle that a settlement puts an end to litigation. So we begin with that, and then if we are going to make exceptions to that, when we're writing settlement agreements, if we are going to make an exception to that, we pull out an exception that, okay, we're going to preserve an underinsured motorist claim.
Didn't you say this was a settlement agreement? It doesn't say settlement agreement. I don't see settlement agreement anywhere. All I see is a handful of words that strike me as ambiguous.
I think there's a handful of words which is an agreement between two lawyers
Could be, but it doesn't mean it settles all claims.
based upon the principles which I've always practiced under, which is when we agree to resolve a matter, we resolve it fully.
But this is not an agreement to resolve it fully, because you still depend on the court system to fill in the blanks of your agreement. And you need to stay behind the podium, because it needs to be picked up by the microphone.
I'm sorry. Waiting for the jury to do one thing, the court system do one thing, and that is to fill in the amount.
But if the verdict is not enterable because of something that happened during the trial, it's not a valid verdict. I mean, that's what the law is. If you make a motion to trial before the verdict's entered, and the verdict is not a valid verdict, it's never entered. How do you have a valid verdict if there is some problems with it?
Well, like I said in my email, we'll see what the jury does.
That's exactly my point I want to make. We've all seen trials where there's a settlement reached before the jury comes back. Doesn't the jury get the kibosh immediately? And we'll never know. The jury did not stop deliberating when you guys entered that high-low agreement. Am I correct?
That's correct.
I mean,
And
it,
the court was not notified until they called with the verdict.
I mean, am I oversimplifying this? I think it seems like most of us up here agree it's a matter of interpretation of the words. The agreement could mean one thing, it could mean something else. Judge Smith, who presided over the trial, had a hearing, and he interpreted the high-low as meaning the case is over and done. So if it is ambiguous, don't we need to, isn't the only question whether there's substantial evidence to support his ruling?
I believe that is correct, Your Honor, and I think Judge Smith was clear what he was told when he advised counsel of the ruling, and that is, thank God I have the high-low agreement, which clearly sets forth counsel's understanding, which confirms our intent, which means I owe $100,000 because it was below $100,000, and this litigation should be done. It should have been done then. That's what we were paying $100,000 for, up to $1 million, to put into this litigation so that these parties can move forward. I briefly would point the court to the case of Trower versus Secura Insurance, which is a U.S. District Court case in Minnesota, and they're quoting a Virginia court, the Virginia Supreme Court, regarding high-low agreements, and it's cited in my brief. But what they said is, unless such right is explicitly reserved, the parties to a high-low agreement shall not be rewritten to impose a right to post-trial or appellate relief that is neither stated nor implied therein. It's essentially the same as right. We have the purpose of a settlement, high-low agreement, ambiguous as somebody may interpret it, is to put an end to the litigation. It is to finalize this matter, and if that was not the intent, then it should have been negotiated by counsel that we're not going to agree to no post-trial motions, we're not going to agree to no appeals.
That Tower case, excuse me, that's unpublished, about 17 years old, and it has not been cited. Am I correct?
That's correct.
And there are several other cases that talk about taking the other position.
There are New York cases, and real briefly regarding the New York cases, the New York cases, number one, are based upon a specific statute, in part. Number two, the one New York case, the high-low settlement agreement was based upon percentages of fault, so many dollars for each percentage of fault. The problem was there was a finding of fault but no proximate cause. You know, that is not our situation. We didn't have any exceptions. We were, in my mind at least, done, 100,000 to $1 million. And that was what we were finally going to decide.
What would be the better policy, if we're gonna settle the issue in Iowa and set up, and whichever way we decide, what's the better policy? Should a high-low agreement that is silent on appeals be deemed you've waived your appeal, or should you have to reserve your appeal rights in writing?
Your Honor, I believe that based upon our principles of settlement to begin with, that settlements resolve all issues unless there's an exception carved out in the settlement. I think the policy in Iowa should be the same for their high-low agreements. Why would it be different? We should have this policy that is uniform throughout, that if you want to make an exception to a high-low agreement, you have to carve it out. Otherwise, it's a resolution as our law encourages resolution. And that's what a high-low agreement should be able to do unless a negotiated carve-out is made.
Thank you, counsel. Mr. Kyle, you may present your rebuttal argument. Before Before you start, would you identify, was Mr. Woodward the offeror in this contract negotiation? Is he the one that initiated
The voicemail?
the offeror? Is he the one that initiated the deal?
Yes. I didn't contact him. He contacted me via voicemail that he left. We never spoke about this.
Okay, and in response to that initiation of a contract, what was your belief that he was offering to you?
The only terms that were offered were exactly what I agreed upon, I believe. Sorry for stepping away. They agreed to the high-low of 100K to 1 million. That's all I wrote. The numbers were the only thing that was agreed upon. And again, somebody could have said that what my intent would have been. If my intent would have been to take the $100,000, never once did I ask for the money. When I found out, and I didn't find out from the judge immediately that I lost the case, I never asked for the money. There were some questions out there about how the court should maybe handle this. You'd have to consider when these are made. Obviously, ones that are made before trial aren't in the heat of the moment. So would they be held to a higher standard of ones that are made during trial when everything's coming at you and you're up all night long, or the ones right before the jury comes in? That's the concern. Do you also worry about the experience level of the trial lawyers that are involved? Maybe somebody's trying his first trial. I think it's a slippery slope to set this and say every single high-low agreement gives up post-trial motions. Every high-low agreement gives up.
No, I don't think we need to go that far, but can't we at least have the proposition that where you enter into an agreement and the agreement is silent, you assume the risk of events that have already happened? I mean, that's kind of a general principle in contract law. If I agree to pay somebody something for a particular thing, then I assume the risk of events that already happened prior to entering into that agreement, and that's kind of the situation we have here. I agree it might be a different case if the high-low had been negotiated in the middle of trial or at the beginning of trial or something else. But here, you knew about what you were going to use as the basis of appeal at the time of the high-low agreement. Isn't that right?
Correct. And I think one thing you talked about is the unknowns. You can never bargain away unknowns. You can never bargain away that juror who sat through jury selection and wanted to screw you with his verdict. Or, on the other side, light him up and never say anything. Same thing about witnesses. In this case, we have an example. That's about the jury question. I don't know, and I don't know to this day, whether the judge called Pat direct about that jury question. He didn't call me. I never found out about it until afterward. So, I see what you're saying. Giving away unknowns would be something if you could do it, but they're still unknowns. It cuts both ways. It could be a high verdict, it could be a low verdict. What if the jury question was this? Can we give more than $2 million? And then I got the high-low of 101 million. I never knew about that jury question, and they come back with $5 million. I lost my appeal on an unknown. That's.
I think that might well be the case. I mean, you can bargain away unknowns. I think I disagree with that.
Is there a course of negotiation here? And I'm interested in what the record shows. Does the record show prior offers? And if so, what does the record show in connection with them?
I haven't seen any in the record. I didn't entertain any, and I didn't negotiate any.
There's no course of negotiations, just this quick exchange.
Just this call in the morning of the 19th, after the jury question was asked on the afternoon of the 18th.
You said you never requested the 100,000. Was it ever tendered?
No. And I don't mean to be speaking out of school to the point that absolutely, you know, the offer was made of, we'll pay our $100,000 because we want an enforced agreement. Tendered, I don't want to get hung up on a, you know, did he bring in a check? I don't want to speak out of school that way.
You're not claiming that he would be in, if the agreement was at this point that they're obligated to pay $100,000 based on the events, you're not claiming they're in breach, are you?
Oh, no.
Thank you, counsel.
Thank you all.
The case of Freer versus DAC Inc. Is now submitted, and we'll next hear the arguments in Barker versus Iowa Department of Public Safety. Thank you, counsel.